All right, the 151st is now in session, the Honorable Mike Engelhardt presiding.
See that?
Jeff, is there anything else you need, sir?
Oh,
Is all working? Style case is Casey Hayden versus court calls Casey Hayden versus Astroworld. Is he bored with it? Astroworld Enterprises.
how's it? Good. Things that you need to do something. All right, very good. So a couple things. I imagine there may be some housekeeping matters. We seem to have a exhibit book up here. Can I get, let me start with announcements for the parties who's here for the planet.
Good afternoon, Your Honor. My name is Hannah Bowersmith, and I represent Ms. Casey Hayden.
Spell Bowersmith for the courtroom.
B as in boy, O-W-E-R-S-M-I-T-H.
And with an H at the end.
Yes,
One in or two?
two, Your Honor.
Seated and, no, I'm sorry. Are you ready for trial?
Yes, Your Honor. Pursuant to housekeeping, I motion to make.
Good. Defense.
Good afternoon, Your Honor. My name is Haley Dunkey. That is H-A-L-E-I-G-H. Last name N as in Nancy, U-E-N-K-E, along with my co-counsel.
And Enrique Contreras.
On behalf of the defendant in this case, AW Enterprises.
Thank you very much. And is the defense ready for trial?
Yes, Your Honor.
All right, so do we have any motions or other matters we need to pick up?
Yes, Your Honor. Would you like housekeeping or motions first?
I will defer to you however you would like to do the first.
Yes, Your Honor. We were able to confer pre-trial and agree on some exhibits to offer for admission at this time. And those exhibits are two.
Are they plaintiff exhibits or these universal exhibits?
For purposes of today's trial, we would ask that universal exhibits and that all exhibits in the file retain their pre-designated markings.
Okay, I'll go on that. I'm not sure what the right verbiage is, but yes. What exhibit numbers are those?
They are 2, 5, 6, and 7.
Read.
Yes, Your Honor.
All right, so for the purposes of this trial, exhibits 2, 5, 6, 7 are admitted at this time.
May we move about the well freely during opening and closing statements?
Any objection? May, and if you want to do that as well?
Yes, Your Honor.
Yes, you may.
May we also invoke Rule 615 for the sequestration of witnesses, with the exception of Ms. Casey Hayden, our Dr. Spencer Edwards, and then their party representative, Ms. Bellman.
Yes, the rule's been invoked, so if there are other fact witnesses here who expect to testify, you'll have to leave at this time. If you see somebody coming in or someone and you know that they're a witness, please alert the bailiff or me, and then we will excuse them.
Thank you, Your Honor. The last
And, oh, and that goes for Zoom as well. If any of you fact witnesses are watching a live stream, you must turn it off at this time. If you were other than the folks that we just mentioned.
Thank you, Your Honor. The last housekeeping matter that we have is that we would like to ask that the jury charge be read constructively prior to closing arguments.
Any objection?
No objection, Your Honor.
All right, so ordered.
That concludes our housekeeping.
Anything else?
Yes, Your Honor. We just have a few housekeeping matters. Maybe assume that all witnesses have been sworn.
No, I'm going to swear there.
And then we
That's
just
much
ask,
more.
for a brief recess at the conclusion of the plaintiff's case.
Objection?
No, Your Honor.
All right, if you all, and actually, if you do need, anybody needs a break, please let me know. We can go down the hall, et cetera. I will be endurance competition. Anything else?
They're ready to proceed. proceed pursuant to a motion in limine in 2 parts.
Did you have a separate motion, Lily?
Yes.
Okay, let me let them go, let me hear their motion, and then I'll be happy to hear yours, okay? Please.
As your honor is aware, this is a defamation case in which AW Enterprises published a statement about my client Casey Hayden, which ruined her reputation, and at the time it was made was false. We anticipate that the defense will try to introduce evidence of a particular incident that occurred in October. The incident that the statement was published regarding happened in November. So
Are these fact witnesses at all?
not to my knowledge, your honor.
Okay, very good. I'm just, because we had invoked the rule, so I wanted to be vigilant about that. Please
Yes,
go
your
ahead.
honor.
Sorry to interrupt.
That's fine. We anticipate that they will try to introduce evidence of this particular incident and use it for propensity purposes, which would be improper under 404A.
To try to prior bad prior bad action in conformity therewith, right?
Correct, your honor.
May I respond, Your Honor?
Yeah, let me hear what's your response to the 404A objection?
Your Honor, as you have heard, this is a defamation case. By bringing a defamation case, the plaintiff has put their reputation directly at issue. It is our stance here today that these prior events are evidence that the plaintiff has had a reputation prior to this statement ever even being published. These evidence goes directly to the reputation that they have made for themselves with their own statements and own acts at Astroworld beyond this statement.
What is the incident, the earlier incident?
This incident occurred
And
in October 2021, 1 month prior to this incident. This incident was the first violation of the membership agreement, which gave rise to the termination upon the second violation. This incident involved profanity and alcohol and is proof of the way that they were acting publicly in their role as a social media influencer at Astroworld prior to the statement ever being published.
In other words, you're saying it has some independent legal significance and goes to the reputation, so it might affect an argument about damages, for example, if any, that such that their reputation was already negative.
Yes, Your Honor.
May I respond?
Yes, please.
I do understand, I do agree with defense counsel that reputation is really important to this case and is at issue. And if they have any witnesses that they would like to call to testify specifically to my client's reputation and character, that's one thing. But to testify about a specific act in the past in order to prove that the statement that was made in relation to November was true, that would be improper. And I would worry that it would confuse the issues and it would be used for propensity.
So what rule then do we look to other than Rule 404A or B with regard to character evidence of that sort?
403, Your Honor.
That would be that it would be unfairly prejudicial.
Yes.
They're not I don't know if there's a rule book here, but okay, very good. Well, I think that I will allow it because I think it has significance under 404.
Yes, Your Honor.
Any other limiting points?
No, Your Honor.
Just a clarification, that evidence will be allowed to come in.
Yes.
And we do have a motion.
Although a limiting point does not preserve error, so you'll need to object if and when that evidence is raised.
Yes, Your Honor.
Preserve error.
We anticipate that the plaintiff in this case will try to characterize the statement in a light that does not reflect what was actually said. In the termination notice, AW
Well, I'm
Enterprise.
sorry, this earlier statement or the one?
The published statement, the statement that was published on December 20th.
I'm sorry, and what about you think they'll do what?
Mischaracterize the verbiage that was used in that statement. The exact verbiage that was used was a public intoxication incident. We anticipate that the plaintiff will try to characterize this as AW Enterprises calling Ms. Hayden a drunk, as in an alcoholic. That was not what was said, and we asked that the plaintiff be limited to the language that was used in the actual publication.
I don't know what the legal grounds for opposing counsel's motion is, but I think that the terms will speak for themselves. I mean, saying that somebody's publicly intoxicated is kind of the same as throwing around that they're kind of a drunk, kind of a sloppy person. And since this relates to reputation and how the general public might perceive this statement, it's important, it's relevant. If I had a legal basis, I could argue on that ground, but
Do you have a rule or case that talks about that?
Yes, Your Honor, under 403, this is far more prejudicial than probative and is just serving to inflame the jury and it's not representative.
Want to respond to 403 specifically?
Your Honor,
Specifically, I'm sorry. Go ahead.
I believe that the terms are kind of interchangeable. So I don't think that they're prejudicial. I mean, AW Enterprises made the statement that they made. They decided to announce to over 500 people that a member was publicly intoxicated, and they're here to take ownership of that. And we're here today to determine whether it's true or false. So if we're talking about, we're equating it to being drunk or messy, that's what the jury might interpret it as. It goes to the weight, not the admissibility.
Okay, I agree. The objection's overruled. I think assuming that evidence comes in, which I undoubtedly will, then certainly in closing argument, you're welcome to make reasonable inferences and characterizations of the evidence as you see it. The risk is yours if you mischaracterize it to the jury and they feel that you are using hyperbole or otherwise mischaracterizing it, going beyond what's reasonable. I think that's why we have jury trials, is to allow both sides some freedom to interpret and argue the evidence. Anything else?
Yes, Your Honor. We anticipate that in order to prove damages, the plaintiff will bring in a out-of-court statement between Max and Molly's Dolly Shop, which is a business that the plaintiff alleges they had a contract with. This is a verbal conversation between Molly and the plaintiff. Molly will not be here to testify in court today, and we ask that this conversation be kept out, as well as Exhibit 10 that goes along with this, which is a text chain between the plaintiff and Molly's Lollipops, which is all hearsay, both the statement and the exhibit.
You're saying it's an out-of-court statement. These are out-of-court statements offered for the truth of the
Yes,
matter.
Your Honor.
Our response to the hearsay, it sounds like there's two hearsay objections, one to the verbal statement and one to the text message.
Yes, it's my understanding that Ms. Hayden had personal conversations with Molly and can speak to her understanding of their agreement or whether or not they still have an agreement. As far as the text messages themselves, I do have exceptions for those. There are different exceptions for different messages. In the event that we get there, I don't anticipate talking about or quoting any language and opening. So maybe it would be more efficient to take that up at the time that I attempt to offer the exhibit.
Let's go back to the first one, the verbal. You said you expect her to testify about her understanding. Can you elaborate?
Yes, I'm not going to try to elicit any particular statements that Molly or Ms. Hayden made out of court. Just what her understanding was of the deal that they were going to have and whether or not they still had it today, or whether or not it had it.
Okay, I'm not going to pre-admit the evidence. We'll have to take it up and you'll have to object at the appropriate time. Okay? Anything else?
No, Your Honor, we are ready to proceed to opening statement.
We're also ready.
All right, let me ask the defense to have a seat. How much time do you get or want for opening?
10 minutes works just fine. I probably won't take the full time.
All right, let's bring in the jury. Okay, they're seated. 224. You may proceed.
May it please the court. Reputation. What is a reputation? It's something that often takes years, even decades to build, and just seconds to destroy. In today's case, all it took was one email. One email from one of the largest companies in Texas, AW Enterprises, the heart of Texas theme parks. If AW Enterprises sounds familiar, that's because they own Astroworld. And all it took for AW Enterprises to ruin Miss Casey Hayden's reputation was one lie in one email sent in December of 2021. That's why we're here today. You see, Miss Hayden has brought a defamation claim against AW Enterprises for the statement they made because it was false and it caused her harm. And our legal system allows Ms. Hayden this opportunity as a remedy for what happened to her. And I want to talk about what AW Enterprises did, but before I do, I want to introduce you to Ms. Hayden. This is Casey Hayden. She is a small business owner and she works hard for her money. She works for herself, she sets her own hours, and she's escaped what many of us may have hoped to escape someday, and it's the general 9 to 5. She works on her own time. She does what a lot of people would think of as advertising and marketing. Now, a brand comes to her with a product or something that they want to sell to people. Ms. Hayden takes that product, and with her creative genius, she takes pictures, videos, she edits them, and she makes it into something that is kind of like a commercial. But instead of just sending it off to a TV company, she posts it on her social media platforms. Those include Instagram, TikTok, X, and she advertises it to her followers. You see, Ms. Hayden has built a big following, and she has done so in part because of her love of Astroworld. Her followers connect with her content and engage with it, and brands want to reach out to her for that reason. She posts things like food, rides, attractions, but that's not all. Because she loves Astroworld so much, she joined AW27, which for anyone who doesn't know, that is peak Astroworld. It is Astroworld's most exclusive club that offers exclusive restaurants, better hotel accommodations, special seats at concerts, great restaurants, and even after hours parks, where you get to go around the park when everybody else had to go home. It was a behind the scenes look. Then, on November 24th, 2021, her membership was terminated. I want to make it very clear that Ms. Hayden is not bringing a claim because her membership was terminated. She's bringing a claim because AW Enterprises announced why she was terminated, in their opinion, and made a false statement when they did so. Now, we have to prove to you today by a preponderance of the evidence that the statement that was made about Ms. Hayden was defamatory. In other words, it harmed her reputation, that it was false at the time that it was made, and that AW Enterprises knew or should have known that it was false. A preponderance of the evidence is a standard that the judge is going to give to you. He's going to instruct you on the law. But I want you to think of it like this. It is the greater weight of credible evidence today. You're going to hear witnesses take the stand, and they're each going to give a recount of what they remember from November 24th, 2021. Ms. Hayden's going to tell you what she remembers from that day, and her doctor is going to tell you what he knows to be true about Ms. Hayden. The defense may call some witnesses today. They do not have the burden in this case, but in the event that they do, they're going to tell you their version of the events. And what you're going to be doing is evaluating the credibility. I want you to imagine that the plaintiff and the defense start out on equal footing. We start here. And as you start to hear the testimony of the witnesses, you will determine who you believe more, who you find credible. You see, Ms. Hayden's going to tell you that on November 24th, 2021, she was suffering from a vestibular migraine. It's something that Dr. Spencer Edwards is going to testify that he'd been treating her for 7 years.
Doctor, I don't need you nodding during the opening statement. Okay, please try to be a little more reserved. Thank you.
May I proceed?
Yes.
You're going to learn that vestibular migraines are not exactly like a regular migraine. You see, it's not just a pounding, throbbing headache. There are other symptoms associated with it. Symptoms that you're going to hear look a lot like somebody who may have had too much to drink. But you're also going to learn that that's not something that the average person might be able to tell the difference about. And that maybe an investigation was needed. In this case, you're going to learn an investigation was not done. No blood alcohol content was ever taken. No independent medical examination was ever done of Ms. Hayden. Yet AW Enterprises published that statement. We're going to be asking you for damages in this case. And we talked about it during jury selection, and you all agreed that if the evidence supported it in this case, that you would be able to award monetary damages for things like injury to reputation and mental anguish. Now, we understand that these are kind of intangible things. They are hard to ground. We're going to bring you evidence of Ms. Hayden's damages for loss of followers, loss of brand deals, and her mental anguish that she suffered as a result of this, the embarrassment that all of this has cost her. And I want to put it in your heads right now, just so you're not surprised later, this is not a $100 case. This is not a $1,000 case. This is hundreds of thousands of dollars we're talking about. So that's what we're going to be asking you for at the end of this trial, and we're going to give you the evidence that you need to write those numbers in those blanks. Reputation is important. It's important to each and every person in this room. And it's important to verify what you're saying before you share it with the world, especially when you have a platform as large as AW Enterprises. I trust that by the conclusion of today's evidence, you will come to the only conclusion that the evidence supports, and that it will be AW Enterprises is liable for defamation. Thank you.
Thank you very much. Does the defense have an opening they wish to make?
Yes.
No. Did I say it right? No?
Yes.
Yes.
And please support.
Yes, it's 2:32.
Every decision has a price. Every action has a reaction. And every choice has a consequence. Members of the jury, you are going to see that that is exactly the case here today. All of those principles apply directly to what happened here today. You will see that Miss Casey Hayden made a choice. And that choice had consequences. But rather than dealing with the effects of those decisions, she has made a choice to bring us all here today to try and find someone else to blame. Members of the jury, my name is Haley Youngke, and together with my co-counsel, Enrique Contreras, we are proud to represent the defendant in this case, Astro World Enterprises, also known as AW Enterprises. Many of you may already be familiar with Astro World. Maybe you grew up going to the parks, or maybe you bring your own children there now. Astro World prides itself on the feeling that you get when you step through those doors. Imagination, wonder, magic. Astro World has a duty to its paying customers to keep that magic alive. And Astro World found a way to carry this magic from something you may only experience as a child and bring it into adulthood. They did this through the creation of AW27. AW27 is an adult-focused, membership-based club. It provides exclusive access, benefits, and perks to its members. And you're going to hear that Miss Casey Hayden was a member of AW27. In fact, AW27 was part of what made her social media career successful. However, you're also going to hear that sometimes things aren't exactly as they appear on social media. Because today, you're going to hear that the way that Miss Hayden acted at the parks is not representative of her online profile. You see, you're going to hear about the multiple times that Miss Hayden had to be cut off from drinking. You're going to hear about a violation, her first violation of the membership agreement that she agreed to when she became a member. She was using profanity in front of children, in a place that's supposed to be magical. And then you're going to hear about the violation that brought us all here today. The incident that occurred on November 24th, 2021. You'll hear that on that day, Miss Hayden was at the park, slurring her words, reeking of alcohol, unable to talk, unable to stand, eyes glassed over. You're going to hear that she was found by Eric Bauman and Officer Rubenstein. And they're gonna walk you through why they determined that Miss Hayden was drunk that day. They're gonna walk you through the process, the decision that they had to come to because they had a duty to the other paying customers of Astroworld. And they had to terminate Miss Hayden's membership. And then they posted to let the other members know what had happened. Members of the jury, as you have heard, this is a defamation case. And the question that this all really boils down to is really simple. Was Miss Hayden drunk on November 24th, 2021? And just as this is a simple question, there is a simple answer. The evidence will show that Miss Hayden was in fact drunk on November 24th, 2021. You're gonna see this through 4 witnesses today. Miss Hayden herself will testify. And when she does, she will have to tell you she ordered 6 beers that day on her account, just a matter of a few hours. She'll tell you that she was there with a friend. You're not going to see a single ounce of evidence of that friend being there. Not a picture, not anyone to verify that. Miss Hayden will tell you that all of these symptoms that she was experiencing were due to a vestibular migraine. And she's brought her doctor here today to testify to that. I ask that you listen closely. I ask that you pay attention and weigh for yourself the credibility of that doctor's testimony. Because what you're not going to see today is a single medical record. The doctor will tell you that every record of the alleged treatment for the last 7 years has suddenly disappeared. That doctor will tell you that they never once even prescribed a medication for this apparent debilitating condition. This doctor will have to tell you that at the day of the incident or any day after, did they ever see Casey for this condition. But you're also going to get to hear from 2 other witnesses, Eric Bauman and Officer Rubenstein. The only 2 people that you will hear from that saw Casey Hayden there that day, that smelt the alcohol coming off of her, that interacted firsthand with Casey Hayden. And they will explain to you what they saw and how, using their certifications and their experiences as officer, that they came to their conclusion. The plaintiff explained that they do have the burden of proof in this case. And members of the jury, I ask that you hold them to that burden because I am confident that they will not be able to meet it. I am confident that the picture they paint for you today will be full of holes, holes that there is not evidence to fill. And for that reason, I'm confident that at the end of this trial, when viewing all of the evidence presented to you, you will come to the only conclusion that justice demands and find in favor of the defendant, AW Enterprises, and find them not liable for defamation.
All right, very good. I'll ask that the plaintiff please cite first.
Plaintiff calls Casey Hayden.
Please come up and stand and be sworn. Please raise your right hand. Do you solemnly swear or affirm the testimony you will give in this trial be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, please have a seat. I'll give you some more instructions.
Your Honor, may I have a question from the podium?
Yes, you're free to move around the courtroom, use whatever's not nailed down. All right, please have a seat. Please remember to speak loudly and slowly and clearly so we can all hear you and our court reporter can take down what you're saying. All right. We have a limited amount of time, so please keep your answers brief and to the point. Just answer the question that you are asked. Don't volunteer extra information. I promise the attorneys will ask more questions if they want more information. And then finally, as you can imagine, our court reporter can only write one person speaking at a time. So even if you can anticipate some of the questions, please wait for the whole question before you begin your answer, and I'm sure the attorneys will do likewise, yes?
Yes, Your Honor.
All right, may I proceed?
Good afternoon, Ms. Hayden.
Good afternoon.
Can you please introduce yourself to the jury?
Yes, my name is Casey Hayden.
How old are you?
I'm 28 years old.
Where are you from?
I'm here in Houston, Texas.
What do you do for a living?
So I would describe what I do as being in marketing, advertising. Essentially, I'm kind of in the world of being able to promote brands on social media. So colloquially, what people like to call a social media influencer.
Explain to us a little bit more how you are a social media influencer. What do you do?
Sure. So I have a number of platforms. I have a Facebook account, an Instagram account, TikTok, and on these platforms, I will post. And what will happen is that brands will reach out to me in order to make posts about their products or any campaigns that they're doing so that they have access to the people that follow me. And I have a pretty big following.
What does compensation look like for a job like that?
So as I mentioned, I make these posts. So compensation, or excuse me, I can be compensated for a number of things. So sometimes the compensation might just be for making the post. Other times, or in addition, I can be compensated for the number of people that view the post, the number of people that engage with the post, number of people that visit their website because of the post, or even how much my post makes their sales increase.
Is that your only source of income?
That is correct.
How much are you making?
At this time, I am making barely $35,000 a year.
And is that how much you have always made in this role?
No.
When did your income change?
My income changed in the year 2021. Prior to that, I was making about $100,000 a year.
So the question was, when did that change?
I apologize, Your Honor. In December of 2021.
What were you making prior to December of 2021?
I was making about $100,000 annually.
Now I want to shift to talking a little bit more about your content. Aside from the brand deals and the products, what kind of content were you posting?
Primarily, my content was about Astroworld.
So what kinds of things from Astroworld would you post about?
So I would post about the food options there, the rides, the entertainment. I would also post about AW27.
For those of us who are a little less familiar with Astroworld, I know you're a big fan. What is AW27?
Well, AW27 is an exclusive club within Astroworld.
How do you join?
So joining is quite an arduous process. First, you have to submit an application. I had to wait 2 years while they vetted my application. After that, you have to have an upfront $15,000 payment, and at which point you again have to pay $5,000 annually to maintain being an AW27.
So once you obtain membership, what kind of perks or benefits are available to you?
Plus, we have access to the park at times, like in the evening when other people might not be able to be on the park premises. We have access to different food options, different rides, merch. It's a great club.
Are you still a member?
I am no longer a member.
Was that a voluntary choice?
It was not.
Now, just to be clear, are you bringing this lawsuit because your membership was terminated?
No, I am bringing this lawsuit because the defendants lied.
I want to talk more about what led to that statement being released that you're talking about. Do you recall when you were informed that your membership was terminated?
I was informed that my membership was terminated on December 26th, 2021.
What's your understanding of the reasoning that was given to you?
The reasoning that was given was that they thought I was publicly intoxicated when I was on the Astroworld campus on November 24th, 2021.
Is that true?
It is not true.
Take us back to that day. What do you remember doing?
Well, as I said, I was on the Astroworld campus. I was there with a few friends, and we were just having a good time.
Did you have anything to drink that day?
Personally, I had maybe 1 to 2 beers.
Did you purchase more than that?
I did. Because I was the person with the membership access, I had my tab, and on that tab, I had 6 beers.
If someone were to take that witness stand today and testify that you smelled like beer, do you have any understanding why that might be?
I do.
Why?
Well, they would be right, because one of those 6 beers ended up all over me, and actually spilled on my clothing. So I would understand that someone might think I reeked of beer.
So you're hanging out with your friends, you've had a beer, what happens next?
Well, we were I was near the Texas tornado. It's one of the rides on the campus, and I was hit with what I know to be a vestibular migraine, and I started experiencing the symptoms of that.
What is your understanding of what a vestibular migraine is and what you experience?
A vestibular migraine is essentially a headache, but so much worse. For me, I get dizzy, I get disoriented, I'm not able to stand up straight, I have difficulty speaking, I may be slurring my words, so it's quite an ordeal to go through.
Do you remember running into anyone while you were suffering from this vestibular migraine?
I do.
Who do you remember seeing?
I believe his name was Andy. He was a security officer.
Do you remember what happened after that?
I do. He and someone else helped me, Andy helped me get to a bench and sit down. And I ended up going to the infirmary so I could take a quick nap.
Did you leave the park that day?
Yeah, after my nap, I left on my own accord.
Did you receive any kind of communication in relation to this November 24th incident?
I did. I was emailed about the incident.
And what do you remember from that email?
Well, I was emailed that my membership was going to be terminated because they believed I was publicly intoxicated that day.
Did you do anything to appeal that decision?
I did.
What did you do?
Well, I gave them what I know to be true about my condition and what I experienced that day, that I was having a vestibular migraine. And I provided a letter from my doctor to substantiate my condition.
Would you recognize that email and that letter if I showed it to you?
I would.
Got our permission to approach the witness and also publish what has already been admitted as Exhibit 6.
Any objections?
No objection, Your Honor.
You may.
Thank you.
And you don't need to ask to approach this witness any further. You're welcome to.
Thank you, Your Honor.
I would ask though, if you're going to have, if you have a number of exhibits to give the witness, that you give the witness those exhibits all at once, rather than having to go back and forth at the same time.
Yes, Your Honor. From this point forward, I will. So I'm going to turn your attention to this email here that looks like it's sent from you. Without, reading the entire thing, what is the gist of what you communicated to AW Enterprises?
What I just said, I told them that I was having a vestibular migraine that day, that what they saw were the symptoms of my vestibular migraine, and that I was providing a letter from my medical doctor showing them that I have this diagnosis of a vestibular migraines.
I'm going to show you that letter from your medical doctor. Is this the letter that you're referring to?
Yes, it is.
And again, without reading it, what is the gist of what this letter is communicating to AW Enterprises?
It's communicating that I have a diagnosis of vestibular migraines, and it describes the symptoms of vestibular migraines.
Now I want to turn your attention to AW Enterprises' response. Do you recognize this one?
I do.
Who's it from?
It is from someone named Eric Bauer.
I'm sorry, what are the exhibit numbers? What was Dr. Spencer's exhibit number?
It's all combined. I'm sorry, the letter is Exhibit 5.
The letter, which one?
The Dr. Spencer Edwards letter.
Okay, so that's exhibit 5, and now we're looking at.
Exhibit 6.
All right, it's better for the record if we know the exhibit numbers, please.
Yes, Your Honor.
So this is an email from the defendant, from somebody representing the defense, Mr. Bauman?
Yes, Your Honor, it's my understanding.
Email, right?
Yes.
Go ahead.
Now, I want to turn your attention to the second sentence of the first paragraph. What does that say?
I'm sorry, the second sentence of the first paragraph.
Yes.
Would you like me to read it?
Yes.
Okay. It states, quote, "As you may recall, I was actually with you when you had your episode in November."
And what does the third sentence say?
It states, quote, "Although you were certainly incapacitated, nothing in your doctor's note would substantiate your claims of a vestibular migraine."
What about the second paragraph?
The second paragraph reads, "Although I would not like to believe any of our members would ever misrepresent their medical conditions to us, unfortunately, I cannot reconcile your alleged condition with what I saw with my own two eyes that day."
From your understanding, do you think that that doctor's note was ever given any kind of weight? Objection, Your Honor, speculation.
Response to the speculation objection?
I'm asking for Ms. Hayden's understanding based on her email communications with AW Enterprises.
Okay, at this point, I'll sustain it, but if you have other documents that shed light on that, that are admissible or already admitted, I'll be happy to see those.
Yes, Your Honor.
The objection sustained.
Aside from this email from Ms. Bowman, did AW Enterprises ever communicate with you individually regarding this incident?
Yes.
Did they ever follow up and ask you for a formal statement of any kind?
No, they did not do that.
So to your understanding, was there an investigation done?
Not to my understanding.
Now, was this termination ever publicly communicated?
It was.
Would you recognize that email if I showed it to you?
I would.
Your Honor, permission to approach the witness with the remainder of the exhibits I have to cover with her.
Yes, as I said, you're welcome to approach the witness. Go ahead.
Thank you.
What are we looking at?
We are looking at an email that is sent out monthly to all the AW 27 members.
And this is exhibit 7 for the record. What date was this email sent?
This was sent on December 20th, 2021 at 10 a.m.
I want to turn your attention to the second page. What are we looking at under membership termination?
This is that public statement made about me where they're claiming that I was publicly intoxicated.
What is your understanding of how many people this email goes out to?
To my understanding, it's easily 500 people.
How has the email that was sent out to everybody affected you personally?
Well, it's destroyed my career. It has cut, first and foremost, it has completely embarrassed me in my line of work. No one wants to work with me. People believe lies that have been made about me, and my income has been cut by 2/3.
Have you lost followers from this?
Objection, Your Honor, speculation.
She maintains her own social media accounts and has personal knowledge of how many followers she had prior to the incident and after.
She is not in the brains of each individual follower. The question as it was stated was, has she lost followers because of this? She does not know the cause for the loss of followers.
That's fair. Rephrase your question.
Yes, Your Honor. Have you lost followers after this?
I have.
And did you lose any brand deals after this?
I did.
Would you recognize text messages regarding that brand deal if I showed them to you?
I would.
I'm going to turn your attention to exhibit 10. It should be in your stack maybe towards the back.
Yes, I have it.
Do you recognize these text messages?
I do.
How do you recognize them without going into the contents?
Lots of ways. So I can tell it's a screenshot from my phone because my messages are on the right-hand side, and I remember writing them. And the messages I received are from the left-hand side, and I remember reading them. I also see the saved contact on my phone, Molly, and a photo of her.
Is it a true and correct copy of the text messages as you remember them?
It is.
Your Honor, I offer Exhibit 10.
Objection, Your Honor, on hearsay grounds. Both the messages in gray, these are from Molly, and they are being offered for the truth of the matter asserted. Molly is not here to testify today to these text messages.
I see.
Therefore,
These are, I think I have that. Hold on, this is exhibit 10.
Yes, Your
I
Honor.
have number 19, Your Honor.
Oh, all right. So you're saying you're objecting to all of the gray ones?
All of the gray ones, as well as honestly the green, even though these are the statements of the plaintiff, these are out of court statements that still and would qualify as hearsay.
All right, response to the hearsay objection?
Yes, Your Honor, we're happy to redact any of the green text messages because the state is here to testify to whether or not the statement was true, so they're not necessary. As far as the first message, may we assume we're outside the presence of the jury?
Yes, in fact, ladies and gentlemen of the jury, we need to take up some legal business, so I'll ask you to step into the jury room constructively. Go ahead.
The first statement, I don't have a copy in front of me, but it says that I just saw the AW27 email. You were drinking at the park, and
It says you were drunk at the park, question mark, exclamation mark.
yes, Your Honor. So the first part of that is I just saw the email. If you look at the date, it's December 20th at around noon, and that's the same day that the email went out. And based on the communication, you can tell that it's a present sense impression. As regards to the question afterwards, it's not being offered for the truth of the matter asserted because it is not an assertion. And we certainly don't believe that to be true, so that's not why we're offering it.
May I respond?
One moment. Okay, yeah, but I don't want this to take all day, so real quick.
Yes, Your Honor. The time on these text messages is 12:33. That is 2.5 hours after the newsletter was sent. In order for this to qualify as a present sense impression, this would have to be made at or almost contemporaneously with the publication of the newsletter. Therefore, this is not a present sense impression and would not qualify as an hearsay.
Any other exceptions under 803?
I can attempt to offer it as a business record if you'd like. For the remainder of the two messages, I was going to say 8033. And in relation to the present sense impression for the first one, it says I just read the email.
Right, I think the nature of email is such that it might be published at one point and someone else see it later, right? Okay, as to the first one, I will overrule the hearsay objection. All right, what about the next one?
The second and third one falls under 8033, the then existing mental condition. She's expressing a plan to no longer work with my client.
Can I respond?
Yes.
Your Honor, these are being offered for the truth of the matter asserted rather than to show a plan. They are offering these text messages to prove the causation of the cancellation of this membership, and that is the only purpose that these are being brought in for.
I agree, Your Honor. Under 8033, we are offering it for the truth.
The next one, let me think about that one. The next one?
8033 as well, for the same basis.
I stand on my previous response.
Okay. Stand by, give me 1 second. It's always best to look at the rule, refresh your recollection, as it were. Okay, I do think it fits squarely under 8033. Both of them, I will overrule the hearsay. There are exceptions to the hearsay rule. All right, so then therefore, 10 is admitted with redactions of the plaintiff's green text.
Yes, Your Honor. I'm gonna grab a copy from you really quick. I gave you my copy. Published to the jury.
We ask that the redacted version be published.
All right, it's constructively redacted.
Ms. Hayden, what are we looking at in Exhibit 10?
So we are looking at a screenshot from my text messages with Molly Lollies.
What did she say to you in the first message?
Would you like me to read it?
Just generally, what did she say?
She's expressing a belief that she just saw an email that claims that I was intoxicated while at AW 27.
What did she communicate to you in the following two messages that she sends?
She's communicating that we no longer have a deal for me to work with her brand.
What was the deal that the two of you had, to your understanding?
To my understanding, we had a deal to where I would be promoting her brand, Molly Lollies, and that I would be compensated through this deal, and I would receive $5,000 every month for 6 months, as well as up to $10,000 scaled bonus, depending on how much her sales increase.
Now, I just want to cover something I anticipate that defense counsel is going to get into before we finish up on what you've lost. Have you ever drank at Astor World on other occasions?
Yeah,
Do you remember drinking at Astor World in October?
I do.
And what do you have to say about your conduct in October?
I have to say, it wasn't my best day, and I take responsibility for my actions.
Did you take responsibility for your actions in that case?
Absolutely,
Did you apologize to anyone you thought you needed to apologize to?
absolutely.
And did that particular day in October impact your deal to your understanding with Molly?
Absolutely not.
Do you recall losing any followers after October?
I do not recall losing any followers.
Lastly, how has this whole experience affected you mentally?
Well, I'm just one person. As I mentioned, I'm a small businesswoman in advertising. It's early in my career, I'm only 28, and AW 27 is this massive conglomerate, and it makes a lot of revenue. I'm just trying to make a living for myself, and I feel like my chosen livelihood that I plan on committing my whole life to, and I was supporting myself, has been ripped out from below me.
Was this embarrassing for you?
Incredibly so. Everyone that I work with, all the brands that I could have worked with, they now know me to be someone who is publicly intoxicated when I never was. I just have a chronic condition.
How do you feel sitting there today?
I feel humiliated. I feel embarrassed. I'm just trying to make sure the truth of who I am gets out there.
Thank you. I have nothing further this time.
Any questions?
Yes, Your Honor. Permission to rearrange the law.
Yes. Please.
Good afternoon, Ms. Hayden. I want to start by talking to you about your migraine condition. Okay. Now, you talk about this on direct. This is a serious condition, right?
I certainly think so.
Vestibular migraines are different than regular migraines.
That is correct.
These migraines are painful,
Yes,
debilitating even.
absolutely.
And you've been dealing with these migraines for years.
That is correct.
And because of the way that migraines affect you, you try everything that you can to avoid them.
I live my life, but sure, I mean, I do my best to make sure I'm healthy.
Make sure you're healthy, and you wouldn't want to trigger a debilitating migraine, right?
I don't want to be a hermit, so I'm not going to stay at home all the time. But I mean, sure, I do what I can.
Right, and any reasonable person with this condition would do what they can to avoid triggering a migraine, right?
I I disagree.
Any reasonable person, if this is debilitating, you have to be locked in a room. You try to avoid that kind of pain, right?
I disagree.
Now you claim you've been seeing a doctor for these migraines.
Yes,
You've been treating with Dr. Spencer Edwards
that is correct.
all the way since 2015, correct?
That sounds right.
That's almost a decade.
Yes, that is correct.
Now, Dr. Spencer Edwards has lost every record of your treatment, correct?
Objection, speculation.
Your Honor, this witness can testify to her personal knowledge of whether or not her doctor has her own medical.
Then, Your Honor, my objection would be it's not relevant what she knows about her doctor's practice. Dr. Spencer Edwards is going to testify today and talk to him about his records. She's not his custodian.
Overruled. You can ask. If you know.
I'm going to re-ask that question. Your doctor has lost any record of you ever treating with him since 2015, right?
To be honest, I'm not sure.
Now, your doctor has never prescribed you a single medication in that almost decade, correct?
So for vestibular migraines, thankfully it can be taken care of over the counters. I don't know if he's prescribed me medications for anything else.
Now, we're going to move on. You talked about your reputation on Direct, correct?
I did.
You talked about how important it was
I did talk about
as an influencer.
absolutely.
And part of your profile, your livelihood is through Instagram, correct?
That is one of my platforms, yes.
That's one of your platforms. And that's the face that you show to the world, right?
One of the platforms or one of the faces I guess.
Permission to approach the witness with Exhibit 8.
Yes, you may.
Now, you recognize this.
Yes, I do.
This is a post that you published
Yes, it does.
From-
Yes, it is.
from your account.
Correct.
You remember posting this.
Yes, I do.
Those are your words in the caption.
It appears so.
It was posted on August 27th, 2021.
That is correct.
And it's a true and correct copy of that post as it was posted on August 27th, 2021.
I believe so.
At this time, the defense moves Exhibit 8 into evidence.
You're offering it into evidence?
Objection under 404A and 403.
Response to the 404A and 403 objections.
Your Honor, this is not improper character evidence. As we've established, this was posted by the plaintiff herself. She has publicly held herself out in August before this incident to be a person that would post this kind of post. And this goes to her character prior to this incident ever happening.
Okay, as I ruled in pretrial, the objection's overruled. You may, so this is Exhibit 8. You offering it at this time?
Yes.
All right, Exhibit 8 is met.
And at this time, permission to publish to the jury.
Yes, you may.
Now, this is a post that is still on your account, correct?
To the best of my understanding, I'll take your word for it.
Now, can you go ahead and read to the jury what you wrote?
Yes, I want to apologize for my language.
It's all right, we're all adults. Go ahead, let's read it. We don't have time for that.
It says, quote, "Do you see that waiter trying to be all cool? Question mark. That is Eric Bauman, who tried to cut off my ass.
Cut my ass off.
I apologize, who tried to cut my ass off at Astroworld's Cosmic. I'm in Club AW27. You think you can cut me off? What a pain in the ass. Piece of shit. Now everyone knows what a jackoff you are."
Those are your words that you posted publicly to your Instagram page, correct?
Definitely wasn't my finest day.
The Instagram page that you claim your business depends on.
One of the pages, yes,
This is the person that you hold yourself out to be.
you could say that.
It wasn't just this. You say that you're sorry for this post, but this wasn't the first time that you used this kind of language, was it? Or the only time that you've used this kind of language, is it?
I mean, I'm an adult, so I may have used this language before.
Right, so let's talk about that October incident. You remember that day, right?
Is there a specific incident in October you're asking me about?
Yes, your first violation at Astroworld. Do you remember that first violation?
Unfortunately, yes, I do.
Now that happened in the Club Cosmic restaurant,
Yes,
middle of the day,
I believe so.
around 3 p.m., right?
That sounds right.
You had ordered 2 bottles of champagne.
Objection, Your Honor. At this time, I just want to re-raise my 4 and 4A objection for the record.
Okay, same ruling, overruled.
You had ordered 2 whole bottles of champagne, right?
Yeah, me and my friend Megan.
And you were trying to order a third,
I believe that is right.
and you were told no, you were cut off.
We were cut off.
You got mad.
Yeah, I did.
You got really mad.
As I said, yes, I did.
So mad that you used some language, didn't you?
I think I did.
Do you remember what word you said?
I don't remember my exact language, but I know it was, I used some vulgarities.
You dropped an F-bomb, didn't you?
I very well might have.
I'm sorry, drop the net.
Yes, can you clarify for the jury what exactly an F-bomb is?
Um,
Hold on. Natalie, you're constructively not here. Never mind, move on.
Now, Club Cosmic, that's a family establishment, right?
once it became a restaurant, yes, it was.
And at the time of this incident, it was a family restaurant, correct?
I believe so.
There were children around you.
Yes, there were.
There were characters in costume.
Yes.
This is a family establishment, and that's the language you chose to use.
Unfortunately, I did.
Let's move on to the second violation, November 24th.
Okay.
You were at Astroworld,
I was.
once again, middle of the day.
I apologize for interrupting. I just asked if we're not using the exhibit, we take it down.
Okay, that's fair. Please take it down. Might confuse the jury.
Middle of the day again.
Yes.
You ordered 6 beers on your account.
I mean, not personally, they were on my tab.
Right. And you say you were with your friend Megan, right?
Megan and some other friends, but I know Megan was there.
No, Megan was there. Well, let's talk about Megan. Now, Megan's not going to be here to testify today, right?
I don't think so. You'd have to ask my attorney.
Megan didn't provide any kind of statement in your defense.
So here we constructively approach.
Yes.
The parties have stipulated to Megan's unavailability in this case, and so I think to try to bring up the fact that she's not here is misleading and confuses the issues.
May I respond? We have stipulated that she is unavailable. As to the reason or her existence, we do not know. I'm just asking her questions about her friend Megan and her unavailability.
So this is Texas, we're in Texas?
Yes.
Okay. I think generally speaking, you don't get to inquire about or comment on the unavailability of the witness that might be equally available to both sides or unavailable to both sides. Lots of standing.
And Your Honor, may I have an instruction to the jury to disregard some of the previous questions regarding that?
So, well, okay. At this time, ladies and gentlemen, you're instructed that in your deliberations, that means when you go back to the jury room after the closing arguments to deliberate and decide on your verdict, you are not to consider the availability or unavailability of Megan.
For clarification on the ruling, am I allowed to inquire as to her other friends that are not stipulated to?
think it's irrelevant. And my objection is not relevant.
Well, I think the same stipulation or not, the same reasoning applies, the same law applies. So I will sustain counsel's objection. No, you may.
It's
In terms, and then we're strictly talking about their availability or not to testify at the trial.
You're an influencer, right?
Yes.
Now, there are no photos or videos or anything of you that day, correct?
I don't know if Afterworld has anything. I don't think I have anything.
You didn't post anything that day,
No.
correct?
No.
And let's go ahead and talk about the apparent medical episode. Now, when that happened, you were next to the Texas tornado.
Correct.
You were found stumbling.
Yes, I was.
That's a symptom of intoxication, right?
It can be.
You were found with glassy eyes.
I believe so.
That's a symptom of intoxication, correct?
It can be.
You were found with slurred speech.
Yes, I was.
That's a symptom of intoxication, correct?
It can be.
You were found smelling like beer, correct?
Yes.
It's a sign of intoxication, correct?
Again, it can be.
Pass the witness.
Any more questions?
Briefly.
All right.
I'm gonna approach the witness with what's been previously marked as Exhibit 1, not previously admitted. Ms. Hayden, what are you looking at?
We are looking at a post on my Instagram page from October 15th, 2019.
And how do you know that without going into the contents?
Well, I can see my handle. I can see we're in Houston, Texas. That's where I'm from. I can see words that I wrote underneath the post, and I can see a photo that I took and put in this post.
Is it a true and correct copy and a fair and accurate depiction of the post and caption as you remember it?
Absolutely.
Your Honor, we offer Exhibit 1.
No objection, Your Honor.
All right, exhibit 1 is submitted.
All right. What is this post dated?
As I said, it's dated October 15th, 2019.
How many likes does it have?
It has 1K, so 1,000, or excuse me, it has 25,000 likes.
Nope. Yes, it does. Sorry. I misread it.
No worries.
Misread it.
And just for clarification purposes, does this caption also include a little bit of profanity?
Yeah. Hell is a profanity.
Now I want to turn back to Exhibit 8 that opposing counsel showed you. What is this dated?
This is dated August 27, 2021.
Does this caption include profanity?
Yeah.
How many people liked this one?
This one is liked by 33,000 people.
To your knowledge, did AW Enterprises publish a statement that on November 24th you were using profanity?
No.
And do you think, in your opinion, that profanity was maybe just part of your brand?
Certainly, some of my followers might think that.
Did you still have a deal with Molly's Lollies despite this profanity?
Absolutely.
And did AW Enterprises ever reach out to you about these posts and say, this is unacceptable?
They never reached out to me.
Thank you.
Any further? Okay, any more questions?
No, Your Honor. No.
All right, you may step down. Please call your next witness.
Dr. Spencer Edwards.
All right, doctor, please come up to the witness stand and be sworn. Please raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. All right, have a seat. I think you heard my instructions to the other witness, loud and slow. Don't speak over the other, over the attorney, and brief and please. Yes, Your Honor. May I proceed?
Good afternoon, Dr. Edwards.
Good afternoon.
Can you please introduce yourself for jury?
Hi, I'm Dr. Spencer Edwards.
And I know this question might be a little redundant, but what do you do for a living?
So I'm retired now, but I used to practice medicine.
What is your connection to this case?
I used to be Casey Hayden's physician.
Now I want to walk through your educational background a little bit. Tell us about that.
Yeah, so I got my undergraduate Bachelor of Science at the University of Texas at Austin, and then I went to medical school at Texas Southwestern, and I got that degree in 1988.
Where did you complete your residency?
Here in Houston.
And where did you work after your residency?
I worked at the Kindred Hospital before I started my own practice in the year 2000.
Do you have any kinds of certifications?
Yes, I'm board certified in internal medicine.
What does that mean?
It basically means that I have sound clinical judgment, I had to take an exam, and I could diagnose and treat patients in this area and deliver excellent care within internal medicine.
Go ahead and move to your involvement in this case. Did you review materials?
I did.
Do you recall what you reviewed?
Yes, I reviewed all the pleadings, all the expositions, and all the exhibits, and all the depositions.
Did you form an opinion in this case?
Yes,
Is your testimony today based on sufficient facts and data?
yes,
Did you use reliable principles and methods that are typically relied upon in your field?
yes,
Did you reliably apply those principles and methods to the facts of this case?
yes,
And do you believe that your opinion today will help the jury in their understanding of the facts in today's case?
yes.
Let's move to your doctor-patient relationship with Ms. Hayden. What were you treating Ms. Hayden for during your doctor-patient relationship?
Yeah, so I was treating her for vestibular migraine since 2015.
Since 2015, so were you also treating her in 2021?
Yes.
What is a vestibular migraine?
So a vestibular migraine is a neurological condition. It's a migraine with moderate to severe pounding or throbbing in one part of the head, and it's accompanied with a sense of vertigo, which is dizziness, nausea, imbalance, vomiting, and you can be confused or disoriented.
How long do they last?
So they can last anywhere between minutes to hours, and sometimes for some patients, they can last days.
Did you reach a conclusion as to whether or not Ms. Hayden was suffering from a vestibular migraine on November 24th, 2021?
Yes.
What kinds of things did you consider?
So I considered the symptoms of Ms. Casey Hayden. I also considered my medical expertise in this medical condition, and I also considered all the exhibits and testimonies.
What was of note, if anything, about the materials that you reviewed?
So it appeared that the symptoms of someone who was drunk are very similar to how someone would suffer from a vestibular migraine.
What are some of the symptoms that you're aware of were observed in Ms. Hayden on November 24th?
Glassy eyes, slurred speech, and loss of balance were all noticed, and those are common in both intoxication and vestibular migraines.
Now, is it fair to say that someone might confuse the two if they don't have the medical background that you do?
Yeah, if they didn't know anything about vestibular migraines, or they just didn't know that she had a vestibular migraine, they could very likely confuse her with someone who was intoxicated when she actually had a vestibular migraine.
What was your ultimate conclusion as to what happened on November 24th?
That she had a vestibular migraine.
Are you aware of whether or not AW Enterprises was informed of this?
They were not. They were informed of this.
And do you remember how they were informed?
Yeah, I informed them via letter on December 7th, and then I emailed Casey Hayden on December 8th.
To your understanding, did AW Enterprises ever retract the statement that they made about Ms. Hayden?
They didn't.
Do you believe the statement that they made to be true?
No.
Thank you. I have nothing further.
Any questions?
Yes, sir.
Rose?
Good afternoon, Dr. Evans.
Good afternoon.
You just testified that he made a determination that Ms. Hayden allegedly did not suffer a vestibular migraine. Allegedly suffered a vestibular migraine on November 24th, correct?
Yes.
I'm sorry, would you rephrase your question?
You just testified that Ms. Hayden allegedly suffered a vestibular migraine on November 24th, 2021, correct?
Yeah, I think she had a vestibular migraine.
And you further testify that you ruled out the possibility that Ms. Hayden could possibly have been intoxicated on November 24th, correct?
I didn't rule out the possibility, but I thought it was impossible.
You She thought it was impossible.
Implausible.
Impossible. Yet, Dr. Edwards, you were not present at Astroworld on November 24th, correct?
Correct.
Therefore, you were not at the infirmary when Ms. Hayden went in for her alleged medical condition, correct?
Correct.
Ms. Hayden did not call you at all on November 24th, 2021, correct?
Correct. She called me after.
She didn't go to your.
Hold on. The question was, did she call you on that day?
Sorry, Your Honor. Yes. No, she didn't. Correct. She did not call me that day.
Please answer only the question that you were asked.
She didn't go to your medical office on November 24th, 2021, correct?
Correct.
You didn't have any physical interaction with Ms. Hayden on November 24th, 2020.
Correct.
You didn't make any type of physical or medical examination on Ms. Hayden on November 24th, 2021, correct?
Correct.
Therefore, you also testify you didn't make any type of medical or physical examination any day after.
I wouldn't agree with that.
Did you examine Ms. Hayden any day after?
Well, it's complex. I examined the expositions, the exhibits, the depositions, her own, what she told me, and she also came into my office after the event.
Did you physically examine Ms. Hayden to either confirm she had suffered a vestibular migraine?
Before or after the event?
After the event.
After the event?
Did you examine Ms. Hayden after the event?
Yeah, she asked me personally after the event to examine her and write a letter to AS Enterprises.
It is your testimony today that you physically examined Ms. Hayden after the event?
I would say so, yes.
Your letter that we just read says that you made your determination based on what you heard.
I'm sorry, Your Honor, hearsay, I believe he's about to quote a letter that hasn't been entered.
It has been entered.
So you're not talking about the report?
The report, I'm sorry, the report. It's a letter report.
There are two letters. I just want to get clarification on which one we're talking about.
The December 7, 2020.
With John.
What's the exhibit number?
Exhibit 5, John.
Proceed.
In your letter, you stated that you made your determination that Ms. Hayden had allegedly suffered a vestibular migraine based on what you heard from Ms. Hayden and a couple of documents. Show me in the letter where you stated that you physically examined Ms. Hayden.
I never stated it in the letter.
But it's your testimony today that you physically examined Ms. Hayden?
Yes.
Hold on, I didn't finish the question.
Sorry.
It is your statement today in court that you physically examined Ms. Hayden after the alleged incident of November 24, 2021?
Yes.
Yet, do you have any type of records to show that you physically examined Ms. Hayden after the alleged incident?
No, I pride myself on patient care.
Dr. Edwards, you would agree with me that as a physician for many years, you've treated many patients, correct?
Correct.
And by law, you need to keep a record of each of those patients, correct?
Not exactly. Would you like me to explain?
Go ahead, please.
So I was retired. I shredded my documents because I'm no longer a practicing doctor. Because I don't want these documents getting in the wrong hands, it was my duty to shred these documents. And it just so happened that there was a malware attack that deleted all the electronic records.
So you have no medical document to give to the jury to show that you made a physical examination on Ms. Hayden the day after the alleged incident, correct?
Like I said, I gave an oath. And when I retired, I can no longer keep those documents.
So the answer to the question is?
Can you repeat the question one more time?
You have no medical record to give to the jury to show that you made a physical examination on Ms. Hayden after the alleged day of November 24, 2020.
Medical document or written record?
Medical record.
Correct.
There's also no medical document to prove that you made a physical examination on Ms. Hayden after the alleged incident.
Correct.
So you have no physical proof to give to the jury, correct?
Wrong. I have this proof. proof, just not medical records.
What physical proof do you have, Dr. Edwards?
I have my depositions, I have the exhibits, and I have the testimonies.
But those depositions are not your depositions, are depositions from other people, correct?
Well, I also have my own deposition.
You have your own deposition, Dr. Edwards?
The letter that was up.
That's not a deposition, Dr.
I'm
Edwards.
sorry, I'm not a lawyer.
No
Your Honor,
problem.
objection sidebar.
Sustained, just ask a question.
Dr. Edwards, you just testified that the symptoms of vestibular migraines mimic the symptoms of an intoxicated person, correct?
Not correct.
You didn't testify that the symptoms of a vestibular migraine mimic the symptoms of an intoxicated person, just right now indirect?
Yes, correct.
So you did testify or you didn't
Would you like
testify?
me to explain?
Correct, go ahead.
You don't mimic. They're similar, but there are things that aren't exactly the same.
I apologize for using the incorrect word. You just testified that the symptoms of vestibular migraines are similar to an intoxicated person.
Correct.
Yet, I'm gonna go, you just testified that you made your medical determination based on what you heard from Ms. Casey Hayden and a couple of documents you reviewed, correct?
Yes,
Those documents, as you said, stated, are the depositions and the letter, except for the medical record of Ms. Casey Hayden, correct?
including the rest of the exhibits.
Including the rest of the exhibits. So you would agree with me that that is subjective evidence, correct? What you heard, what you reviewed. Subjective evidence versus objective evidence.
To me, it doesn't seem subjective, but if you can explain your definition, maybe I can find it clearer.
Subjective evidence is evidence that you personally perceive and read. Versus objective, it's a test, a physical examination. So it's your testimony today that your determination that Ms. Casey Hayden was allegedly suffering of a vestibular migraine on November 24th is based on subjective evidence, correct?
Yes, based off of my experience, the depositions, and all the exhibits that were provided to me.
You cannot sit here today and look the jury in the eye and certify that Ms. Hayden was not possibly intoxicated on November 24, 2028, correct?
I don't understand your question.
You cannot sit here today, I'll rephrase my question, and with 100% certainty state that Ms. Casey was not possibly intoxicated on November 24, 2028.
Objection.
Still don't understand your question. It's a triple negative. What do you ask it positively?
Could Ms. Casey be intoxicated on November 2024?
Anything's possible.
So you agree that it could be possible?
Sure.
No further questions, Dr. Edwards. Thank you. I'll go with this now.
Redirect.
Yes, briefly.
In your medical opinion, is it plausible that Ms. Hayden was intoxicated that day?
It is not possible.
Did you have access to your medical records when you wrote the letter to AW Enterprises?
I did have access.
So did you have an opportunity to rely on your medical records when you wrote that letter to them?
Yes.
Nothing further.
Mr. Contreras, you're kind of trailing off. I'd like you to keep your voice up a little bit louder.
Oh, yes, sir. Will do.
Very good. Okay, all right, so, yes, you may step down. Please call your next witness,
Plaintiff rests.
right?
Yes, Your Honor, at this time, the defense has a motion for a directed verdict.
All right, we'll constructively excuse the jury. They're not here.
We believe that the plaintiff has not met their burden of proof, specifically in relation to the second element of this claim, defamation. We do not believe that the plaintiff has shown that there is a decrease in the reputation of the plaintiff prior to the statement being published compared to after the statement has been published. Even viewing the evidence in the light most favorable to the non-moving party, we believe that no juror could reasonably come to this conclusion on this element, and therefore this directed verdict should be granted.
Response?
Yes, Your Honor, Ms. Hayden took the stand under oath and provided testimony for the jury, which, as you're well aware, is evidence of her loss of income and loss of followers. And we were also able to see in Exhibit 10 that a particular deal that she had been working out with another person was lost. So we have established financial injury and lost reputation, which financial injury is going to be, to my understanding, part of the charge that we agreed to regarding the defamation claim.
Okay, anything else?
No, Your Honor.
All right, so the motion for directed verdict is overruled. Why don't we take a 5-minute break, court reporter, and we can go down the hall. All right, we're recessed till 3:41. 3:41. Please keep an eye on the clock.
No. Okay, I'll ask for permission. Prior to closing. I mean, it's a lot. It's like when turning it. Probably. I was.
One of our witnesses.
Is this the next one?
Yes, sir. Our defense is ready to proceed.
Please go ahead, next witness. Report, please.
I'd like to call Ms. Baumann.
Swear you in. Do you solemnly swear or affirm that the testimony you give in this trial will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, and you heard my instruction, yes? Loud and slow. Please answer the question directly, and only the question that you are asked, and try not to speak over each other, all right?
All right, yes, sir.
Your first name is Eric, is that right?
Yes, Your Honor.
It's a strange name for a, never mind, go ahead.
Trying to make it easy, I know.
Good afternoon. Good afternoon, Ms. Baumann. Can you please introduce yourself to the jury?
My name is Eric Ballman.
And what is your current occupation?
I am currently the manager of Cosmic.
What capacities are you on here today?
I'm here on behalf of myself and also on behalf of AW Enterprises, my employer.
As the manager of Cosmic, who do you report to?
I report to Andrew Dow. He's the CEO of AW Enterprises.
And how long have you been the manager of Cosmic?
Since August of 2020,
What was your current, your previous occupation before you become the manager?
I'm sorry, I didn't hear you.
What was your current, what was your previous occupation before becoming the manager of Cosmic?
So what did she do for a living before that?
Yes.
before I was the manager of Cosmic, I was the assistant manager of Club Cosmic, which was the AW 27, 21 and up nightclub.
And before that, what was your occupation?
I worked at a bar on Westheimer. I started out there as a bartender, climbed the ladder there into bar manager and then assistant manager.
Let's talk about Club AW27. What is Club AW27?
AW 27 is an exclusive club for Astroworld fanatics. It is a exclusive membership that they get to, if they're selected, join and receive perks and benefits through.
And what are those benefits?
That can include special access to the park, first grabs on tickets, merch, private dining experiences, things like that.
How do you become a member of Club AW27?
To become a member, you have to apply. It is not publicized, and there's a vetting process done by Mr. Andrew Dow himself.
Can you please let the jury know what does being a member of Club AW27 mean?
It's an honor. It's an exclusive membership, and to be selected, you have access to all of the perks. It truly is an honor to be a member of this club.
And under what circumstances would a member be removed from the club?
There are certain circumstances like allowing, since these are exclusive areas, allowing non-members into these areas, not paying your dues, in violations of your membership agreement, things such like public intoxication would be one.
Let's talk about Casey Hayden. When was the first time you met Miss Casey Hayden?
I met Casey Hayden in Club Cosmic when I started working there in 2015.
Do you recall ever cutting off Miss Casey Hayden?
I do.
Objection 448 for the record.
Okay, overruled.
You may.
I do remember cutting off Casey Hayden.
Do you remember how many times?
I know it was a couple. I don't have a specific number.
And you mentioned that it wasn't a big deal back then. Why did you say that?
It wasn't a big deal back then because that was when I was working at Club Cosmic. Club Cosmic was the 21 and up nightclub. So it wasn't as big of a deal when it was a nightclub.
Let's talk about the incident at issue. What do you recall from November 24, 2021?
So the club transitioned in after COVID in 2020 to Cosmic, which is the family restaurant. I was the manager and I was working at Cosmic, the family restaurant that day.
And what happened next?
That was when Officer Rubenstein came in to get me and said that someone needed assistance.
Objection, hearsay.
Response to the hearsay objection?
Your Honor, she just testified what she did, not what Officer Room is saying.
I thought she testified about what Officer Rubenstein said. Did she not?
My apologies, I can rephrase my.
No, I'm not. That's not how it works.
I can rephrase it. I can.
All right, so I'll sustain the hearsay objection. It sounds like you were asking or she testified to what the officer said. And I haven't heard an exception to the hearsay rule as it relates to that, so I'll sustain the objection. Please ask another question.
What happened after?
Andy Rubenstein and I left the Cosmic, and that is when we found Casey Hayden on the ground.
And what did you do?
We tried to help her. She was stumbling, couldn't hold herself up, mumbling her words when we tried to ask her if everything was okay. She reeked of beer. We were trying to get help.
Do you have any personal knowledge whether Miss Casey Hayden was drinking that day?
After this incident occurred, I was told to check her membership records, and I saw that she purchased 6 beers over the span of a couple hours.
And what happened next after that?
We took her to the back of Cosmic, and we called the medics.
And after that, what happened?
The medics came and got her about 10 minutes after that.
Did you have to report this to anyone?
I had to report it to Mr. Andrew Dow since we believed that it was a membership violation.
What was the result?
Mr. Dow ultimately made the conclusion to terminate Casey Hayden's membership.
Did you have any involvement?
I have a duty as an employee of AW Enterprises to report any member misconduct.
Hold on. The question was, did you have any involvement?
I made the recommendation to Mr. Dow and brought the membership conduct to his attention.
And what did Mr. Dow's do afterwards?
Mr. Dow is the one who made the decision to make the termination.
Do you believe Ms. Casey Hayden was intoxicated on November 24, 2021?
I do.
Why do you say that?
Based off my interactions with Casey before, this was nothing new. She reeked of alcohol and was exhibiting all the signs of intoxication that I have been trained on.
Ms. Baumann, you just said that you have some training. What training do you have?
I am TABC certified.
Can you please explain to the jury what that means?
The Texas Alcoholic Beverage Commission, anyone who serves alcohol in Texas has to take it. They trained us on how to view the symptoms and signs of intoxication.
What are those signs?
They can include many things, stumbling, mumbling of the words, red eyes, odor, things of that nature.
Can you tell us whether a person has to exhibit all of those signs to be considered intoxicated?
They do not.
Let's talk about the newsletter. Why did you all send out a newsletter concerning Ms. Hayden's termination?
We send out a newsletter because, like I mentioned earlier, this is an exclusive club, so that if a member were to by chance bring Casey Hayden, who is no longer a member, into that club, that's permitted and against the rules.
You said one of those reasons. What are the other reasons?
The other reason is to inform the members again that we take this club seriously, and any violations of policies, we want them to know how to behave in accordance with those, and that we take them seriously.
Ms. Baumann, why mention the reason why the member was removed?
Again, we do this to ensure that they know that we enforce the member code of conduct that they should abide by.
Do you have any interactions with Ms. Casey Hayden outside of Club AW 27?
I do not.
Objection.
What was your determination of Ms. Casey Hayden on November 24, 2020?
She was intoxicated.
Why do you say that?
Based off my training and what I'd witnessed that day and how Ms. Casey Hayden was behaving, it was my conclusion that she was intoxicated.
Thank you, Ms. Baumann. No further questions. I'll pass the witness.
Any cross-examination of this witness?
Yes, Your Honor.
We proceed.
Good afternoon, Ms. Bowman. People don't go to Astroworld alone, usually, right?
It depends.
But you've always seen Ms. Hayden in your experience with her at Club Cosmic with friends, right?
I would say yes. It depends.
To be fair, you don't like Ms. Hayden.
I wouldn't say that.
You would say that she is classless.
I believe I testified to that previously.
I'm sorry. You would say she's disrespectful.
Yes, I believe she is disrespectful.
And it was your recommendation that went to Mr. Andrew Dow that she be removed from AW 27, right?
Yes, all employees are allowed to make recommendations. It is-
Please just answer the question that you are asked. You do not have an unlimited amount of time.
Now, I know you said that you were TABC certified, but you have no medical training, true?
That's correct.
So you're not trained in how to identify the symptoms of someone suffering from a medical emergency.
I know.
Specifically, you have no training in recognizing vestibular migraines.
I do not.
And you have no personal knowledge of Miss Hayden's medical conditions aside from what her doctor sent to you.
I do not.
And her doctor did send you a letter,
That's correct.
and that letter outlined that Miss Hayden did suffer from these migraines.
That is what her doctor said.
And you responded to that letter, right?
I did.
And I want to make sure I quote this correctly. You said that nothing in her doctor's note would substantiate her claims of a vestibular migraine.
That is what I said.
You have no medical knowledge to make this statement, right?
I do not have any medical training, if that's what you're asking.
I'm asking if you have medical knowledge to make this statement,
I reviewed what I was provided.
but you have no medical knowledge to say this.
No,
And you also said, unfortunately, I cannot reconcile your alleged condition with what I saw with my own two eyes that day. Is that true?
that is what I said, yes.
Language there is interesting. You think my client's lying, right?
I know what I saw that day, and I believe it was she was intoxicated.
You think my client's lying, right?
Yes,
Now, you published in that newsletter the reason why Ms. Hayden was terminated, true?
that is true.
But you don't publish to all members anything about a temporary suspension.
We do not.
And that is because you don't want to embarrass the member because eventually they're going to come back to the club, right?
I don't know if that's the reason.
Do you remember giving a deposition in this case?
I do.
Do you remember swearing an oath to tell the truth,
Yes,
the whole truth,
yes,
nothing but the truth?
yes.
Your Honor, permission to approach the witness with her exhibit or her deposition.
Yes, you may.
And for opposing counsel and for the court, I am looking at page 70 of Ms. Bowman's deposition, lines 173 through 180.
What was the line number?
173 through 180. And I'm gonna allow you to read along with me as I read aloud. Ask me if I say it correctly. Answer, no, we don't tell members about suspension. Question, why not? Answer, because the suspension is only temporary and we hope that the suspension will be a warning to the member and that their behavior is not acceptable. We hope that it will cause them to change and we don't want to embarrass them by publicizing it because they will be back once their suspension is over. Did I read that correctly? You did. Thank you. So it's true that you don't publish the reason because you don't want to embarrass them.
Objection, Your Honor. She testified that she didn't remember
Didn't remember what?
whether they had to publish the temporary suspensions. That was the question of counsel.
So in other words, what's your legal position?
Improper impeachment.
Your Honor, I heard the witness say, I don't think that's the reason. And that's why I brought her deposition testimony.
Your Honor, the witness said, I don't remember. That was her.
We had the court reporter to read it back for us. That would be lovely, but that's not what I remember hearing.
All right, overruled.
So just for the record to be clear, you don't publish the reason for a suspension because you don't want to embarrass them.
That's correct.
And we can agree because of that, that publishing something like that someone was publicly intoxicated is objectively embarrassing.
It could be.
It is objectively embarrassing, right? Not that it could be.
It could.
So why is it that you say you think it could not be?
Well, if it's the truth, I don't think it's embarrassing.
Is it something that you would be proud to share with someone that you were publicly intoxicated?
If that's how I hold myself out, I can't speak on behalf of others.
Okay. I'll let the jury sit on that one. You do publish the reason why members are terminated.
We do.
And it's so that, like you said on direct, that members have notice of the kind of behavior that you find unacceptable.
That is correct.
But AW 27 does have a membership agreement,
That's correct.
and that membership agreement outlines the expectations for members,
That's correct.
which includes prohibited conduct.
That's correct.
It also includes public intoxication as prohibited conduct.
That's correct.
And all members sign this agreement.
They do.
So members are already on notice of the kind of behavior that's expected of them.
They are.
The moment that they sign that agreement.
They should be.
Now, you sent an announcement to about 500 people, right?
I don't know the number.
You are aware that AW 27 has about 500 members, right?
That's correct.
So when you send an email to all the members of AW 27, you're emailing about 500 people.
That's correct.
And you did that without ever considering that my client might be telling the truth about her migraine.
We sent the email based on the evidence that we reviewed, and Mr. Dow made the determination.
There was no investigation done.
What we were given at the time based off of her reply is what we went off of.
You didn't conduct a blood alcohol test.
That is not my job description.
Please just answer the question.
No, I did not.
You also did not get a written statement from her on a separate date.
No, I did not.
There was no report written.
No, there was not.
And what you had in your possession on December 8th was a letter from her doctor.
Yes, we did.
And you published a statement on December 20th.
Yes, we did.
Thank you. I have nothing further.
Yes.
Ms. Ballman, was this the first time AW Enterprises published a newsletter concerning the termination of a member?
No, it was not.
Was this the first time that AW published the reason why the member was terminated?
No, it was not.
Did AW single out Ms. Casey Hayden on this newsletter?
No, they did not.
How long did it take from the time you received Ms. Casey Hayden's response letter to the time the newsletter was published?
I believe it was about 2 weeks.
Did you do any investigation during those 2 weeks?
Yes, we did.
What did you base your investigation out of?
The documents that we were provided by the state.
Thank you. No further questions. Thank you as well.
Anything else?
Not necessary.
All right, you may sit down. Thank you. Vance, please call your next witness.
At this time, the defense calls Officer Rubenstein to stand.
Officer. Please raise your right hand. You solemnly swear or affirm the testimony you will give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please have a seat. I think you've heard my instructions, right? Loud, slow, to the point. Don't speak over each other. Please have a seat, and you may proceed.
Hello, could you introduce yourself to the jury?
Yes, my name is Andy Rubenstein.
Now, Officer Rubenstein, can you tell us what you do for work
I'm currently a security guard at Astor World State Park.
and what drew you to this kind of work?
Well, in my former life, I was a police officer and I retired in 2020. Had an itch to get back out into the field, but I didn't want the demands of being on the force. So one of my buddies from back on the force was working as a security guard, and it sounded good to me, so I joined them.
Now, you mentioned your former life as a police officer. How long were you a police officer for?
Over 30 years, 35 years.
And when did you make the switch from a police officer to a security guard?
It was around COVID time, 2020.
And can you tell me a little bit about your role when you were a police officer?
Yes, I was working on HPD's crime suppression unit.
And what does that involve?
Primarily, we were focused on identifying crimes before they happened. So that involved a lot of surveillance, sting operations, things of that nature.
Did that involve you observing people?
Of course, my team and I were trained in observing people for our sting and surveillance operations.
And was that a majority of your career?
Yes.
And can you tell us more about your current role and how that transition happened?
Yeah, so my current role as a security guard requires me to patrol the park. I often interface with the patrons of the park if they're lost or if kids get separated from their parents. It's a lot of fun.
I actually just want to take one step back. Can you tell me a little bit about any training or education that you had prior to becoming a police officer?
Yes, I went to Sam Houston for my undergraduate degree in criminal justice, and then I went straight to the police academy after that.
Okay, so now you're working as a security guard at Astroworld. Can you tell me what a normal day as a security guard at Astroworld looks like?
Yeah, absolutely. So like I said, my main beat is patrolling the park. It's a really big park, so I spend a lot of my time walking, checking in with patrons, making sure everything's okay, that everyone's safe, having a good time. And like I said, if anyone's lost, I'm usually the first person they go to find directions.
Now let's move to the day of the incident that we are here to talk about, November 24th. Were you working that day?
I was.
And where were you working?
I was assigned to the south side of the park by the Texas Tornado and Club AW27's dining room.
Now, what do you remember from that day?
I was patrolling. It was really busy. It was the week before Thanksgiving, or it was the day before Thanksgiving, actually, I believe. And I was outside the Texas Tornado roller coaster, and I noticed someone stumbling.
And what did you notice on this individual?
Yeah, when I approached them to see if they needed help, I could tell that they were pretty disoriented and a little confused. They were slurring their words. They really weren't able to stand up completely. They were stumbling.
So this individual that was slurring their words, stumbling, did you later find out who that individual was?
Yeah, I believe their name is Casey Hayden.
And is that individual here in the courtroom today?
Yes.
Can you go ahead and identify them?
Yes, sitting right there.
Now, can you describe more about how Casey was behaving?
Yeah, like I said, pretty disoriented. Their eyes looked pretty glassy. They kept kind of falling over, so I moved them over onto the park bench that was right there in front of the club.
And what did you do next?
I was a little bit afraid that they might pass out. They looked really sleepy. So I knew that if I went right inside of the dining room, that someone might be able to help me, because I didn't think I was going to be able to help carry them on my own.
And why did you choose to run inside the dining room compared to using another method to notify individuals of the situation?
Yeah, we have walkie-talkies, but I wasn't sure exactly what the response rate would be. Like I said, it's a pretty big park, and I knew someone would be inside AW27. It was open, and they were right there.
So you left Casey on the bench to run and get her help. Were you able to find help for her?
Yeah, the manager of the restaurant was at the hostess stand.
And what did you and the manager do?
I asked them to come outside with me. We approached Casey. At this point, they were on the ground. It looked like they had fallen, like maybe they tried to stand up and were not able to. We attempted to help them stand up. They kind of shrugged us off and took a couple steps away, and it looked like they were going to fall again. So at that point, we wanted to get them away from the crowds to somewhere that would be a little bit safer for them. And that's when we took them around the back of the restaurant into a private room.
And just for clarification, about how far is the club AW27 that you ran to the bench that you left Casey on?
10 to 15 feet, maybe.
And so you were able to get Casey back to the dining room. Can you tell me more about why you made that decision and what you did next?
Yeah, like I said, it was a really busy day at the park. We just wanted to make sure that Casey was able to get somewhere safe. And we knew there was a couch back there, and so I thought that would be a comfortable place for us to wait for the medics.
And did the medics arrive?
Yeah, in about 10 minutes, a couple medics arrived at their golf cart. The infirmary is not at Club AW27, so they needed to take her.
So the question was, did the paramedics arrive?
Yes.
And what happened next?
The paramedics had their golf cart and they transported her away from the club.
What did you do after Miss Hayden was taken away by the medics?
I went back to my patrol.
Now, in your interactions with Ms. Hayden that day, did you perform any field sobriety tests or blood alcohol tests on Ms. Hayden?
No, I did not.
And why did you not do that?
I perhaps in my former life would have, but as a security guard, that is not part of my job duties.
Can you tell us about some of the differences between a role as a police officer and your role at AW 27 as a security guard?
Right, yeah, my job as a police officer was to obtain evidence. And so we were really focused on preserving that. My job as a security guard, my priority is getting people to safety. And so I don't conduct any tests on people within the park. I just make sure I can get them to the right help that they need.
And did you get Ms. Hayden to the help that she needed that day?
I believe so.
Now, did you create any type of incident report for what happened on the 24th?
No.
And why did you not?
I thought I had, but I was informed that there wasn't any record of one. I don't specifically remember sitting down to make one, so I guess I didn't.
Now, I want to talk to you about your interactions with intoxicated individuals while you were a police officer. Did you often encounter these types of individuals?
Absolutely. At the beginning of my career as a police officer, I often had to write tickets for individuals who were under the influence or who were intoxicated. And during my time on the crime suppression unit, I interfaced with a lot of intoxicated people. So yes.
And did you receive continuing education in your career during your 35 years about interactions with intoxicated individuals?
Yes, we were trained constantly.
And considering your education, your experience as a police officer, and everything you saw at the park that day, did you come to a conclusion about what was going on with Miss Casey Hayden?
I did.
And what is that conclusion?
It seemed to me like she was intoxicated.
How we pass the witness?
Any questions?
Yes, Trevor. Good afternoon, Ms. Rubenstein.
Hello.
Prior to being a security officer, we talked about the fact that you were a police officer, right?
That's correct.
That was for 35 years.
Yes,
So as a former officer, you can appreciate the importance of a thorough investigation
absolutely.
and the importance of asking questions.
Sure.
Interviewing witnesses,
Yes.
collecting any potential evidence,
Sure.
and writing a detailed report.
Sure.
Now, you can understand that on November 24th, 2021, you were in a different role.
From
Being a police officer.
yes, I was.
Security officer, police officer, not exactly the same thing.
That's true.
But you were writing reports for 35 years, right?
Yes.
Interviewing witnesses for 35 years.
Yes.
That was your bread and butter.
Yep.
Now, to be fair, you don't have any medical experience.
No.
You don't have any expertise in recognizing symptoms of someone suffering from medical emergency.
No.
And you don't have any medical knowledge about vestibular migraines.
No.
And your job as a security guard really is to just make sure that everyone is safe, right?
Yes.
To make sure that nobody's a danger to themselves or others.
That's correct.
And part of keeping everyone safe is ensuring that nobody's having a medical emergency.
To the extent that I'm able, yes.
And if they are, your job is to get them to somebody who can help them.
Yes.
And in fairness, you did that here.
Yes.
But you did sit Miss Hayden down on a bench, right?
Yes.
And when you sat her down on the bench, she looked passed out to you.
Like she might be about to. She looked sleepy from what I remember.
She looked passed out, right?
Perhaps. I don't recall.
Do you recall ever testifying to that? Would you take my word for it if you said that in the past?
Sure.
And when she looked passed out, sitting on that bench, you walk away
Yes.
and you leave her sitting there.
Yes.
And when you come back, she's on the ground.
Yes.
You didn't leave Miss Hayden in a safe position.
I don't know that I would say that,
Well, she fell on the ground.
but I didn't leave her on the ground.
Well, you left her sitting,
On a bench, yes.
passed out,
Yes.
and then she fell.
Apparently, yes.
Now, you also did not check up on Miss Hayden at the infirmary.
No.
You didn't seek out any medical records related to that, right?
No.
And to your understanding, there are no medical records of Miss Hayden's time at the infirmary.
Not that I know of, no.
No real evaluation done on her.
I can't speak to that.
We don't have a physical document of an evaluation.
I wouldn't know.
As far as you're aware.
As far as I'm aware, I don't know.
And you talked about it a little bit on direct, but you did not perform a breathalyzer test, right? You didn't take any photos that day.
No,
You didn't take any videos.
no,
You didn't try to get a statement from Ms. Hayden later that day.
no,
You didn't try to get a statement from her another day.
no,
You didn't even write your own statement.
apparently not.
And that was part of your job responsibilities,
Yes,
which you were reprimanded for failing to do.
yes.
And because it was your responsibility to write that report, and we don't have one, you're the reason we don't have that report.
Sure.
I have nothing further. Yes.
Okay, go ahead.
Is it your job to follow up with Casey after the incident to see how she is doing?
No, it is not.
Is it your job to get her medical records from the infirmary?
No, it is not.
Had you made a report on November 24th, would it have changed anything that happened with Ms. Hayden on that day?
It would not have.
Would it have changed your opinion and conclusion that you came to about what happened on that day?
No, it would not have.
Pass the witness.
Anything else?
Not necessary, Your Honor.
All right, very good. You may sit down. Thank you. Please call your next witness.
At this time, it is that.
Anything for the plan?
No, Your Honor. We are ready to proceed.
All right, you ready to go with closing arguments or do you need break?
A brief recess would be, meaningful to us.
All right, take another 5-minute break. It's 4:12. We'll be back by 4:50. Recess.
I have a copy of the questions for me, but, she's all lots of things, yeah, so. Okay. I didn't, like, even looking, I was just speeding through it, so I was like, if she's on, if she's not, if we're like, I'm just gonna go. Go whatever place you want to, you know, when she, I was like, okay. So whatever.
While we're auditoring, is it okay if I rearrange the well? Sure. Or would you like it? Try to place it somewhere where
everyone can see that nobody's being blocked, so maybe like. Trying to figure out. Maybe like right here? You just wanna make sure that the. You guys can do I'm not trying to block anybody, so I'm trying to, make sure that.
Wait, move it up, and I think we'll still be able to see it there.
Well, it's like where she's standing.
Right, yeah.
Like right here?
And we can just see your face.
It's not perfect, is what it is.
But that's just how it's okay.
You want a marker or something? Yeah, that's what I was thinking, because the other one. Looks like there's a red one, a white. That's me. You want more shine? Yes. What color? This red actually looks so good. Oh, is real, green. What are you wearing? You were so
Those have his name.
Yeah. No one's gonna steal your pen.
You're following my,
Probably was distracted, checking the tenor on there like they do.
Well, usually blonde, like,
Exactly.
so,
Exactly.
I am,
Anytime I'm not sleeping is all my time has been occupied organizing.
You're like double duty.
right, yeah, that's hard.
Yeah. You have any questions?
Yeah, okay. You should.
Yeah. Or it's like important. You were on, like, you've been doing it on your own, what?
Missing one juror. Yeah. All right, now it's time for closing arguments. About how much time do we have set aside for these?
Your Honor, I would request 15 minutes in total. I don't anticipate using all of them, but if I have 1 minute reserved for rebuttal.
14:01.
Yes.
Everybody else?
Only 10.
Have a- All right, very good. Does the ladies have a closing argument you wish to make?
Yes, Your Honor, before I begin, I would just request that since I do not have a co-counsel, that Ms. Hayden be able to put things on the Elmo for ease of the room and.
Sure, I mean, I think a party could do that regardless, so sure, they can help.
Thank you, Your Honor. I'm ready.
Yes, please go ahead. It's 4:20.
Okay, please report. actions have consequences. That's what AW Enterprises said to you in the beginning of their opening statement. Actions have consequences. And as the plaintiffs, we agree, actions do have consequences. When you make a choice to publish a statement to over 500 people, and you ignore the medical expertise of someone who knows about a medical condition that could make that statement false, you should think about publishing it. You should do an investigation. You should look into that. Those are all things that AW Enterprises failed to do here. And actions have consequences, so today we're here for that reason, to hold AW Enterprises to their actions. We have the burden of proof in this case as plaintiff to prove to you by preponderance of the evidence that a statement was made, the statement was defamatory, it was false, and that AW Enterprises knew or should have known it was false. We brought you evidence to prove that to you. Now, the judge just instructed you on the law and read to you the questions that you're going to be answering in the jury room. And so to kind of help us walk through the evidence, since you've heard all the stories, I want to ground this discussion in the questions. We're going to start with question number 1. The first question you're going to have to answer is going to ask you, did defendant AW Enterprises publish a statement regarding plaintiff Casey Hayden being publicly intoxicated on November 24th, 2021? This statement is probably the easiest statement, or this question is probably the easiest question that you're going to get back there. Because all you have to do is look to Exhibit 7. You'll have all the exhibits back there with you. And if you turn to the second page of Exhibit 7, you're going to see the membership termination. The membership termination outlines that Casey Hayden was terminated due to a public intoxication incident. We've heard testimony from multiple witnesses that this was sent to all of AW27, 500 members. The answer to question number 1 is very plainly, very clearly, yes. So because you answered yes to question number 1, you're going to move to question number 2. This question is going to ask you, was the statement in question 1 defamatory concerning Casey Hayden? There's a definition given there, and we're relying on the ordinary person, which for purposes of today's trial, that is U12. We did not ask you to check your common sense at the door. Would an ordinary person find this statement to be, in other words, do you all find the statement to be a statement that tends to injure a living person's reputation and thereby expose them to public hatred, contempt, or ridicule, or financial injury, or impeach their honesty, integrity, virtue, or reputation? Is this something you'd be proud to tell your mom? Is this something you'd advertise in a job interview to get hired? The answer to those questions is no. You heard Ms. Hayden take the stand and talk about how much this has embarrassed her, the mental anguish that she has suffered, and how humiliated all of this has made her feel. You've also heard about her financial injury, which includes the decrease in salary from $100,000 to $35,000, the loss of a brand deal that you saw in these text messages between Molly from Molly's Lollies, and you heard her testimony regarding what that was going to look like. $5,000 a month for 6 months, and potential for $10,000 in bonuses. You've heard clear evidence in the record today that supports the fact that the answer to question number 2 is yes. So when you answer yes to question number 2, you're going to move to question number 3. This is the question that we've spent most of today talking about. It asks you, was the statement that Casey Hayden was publicly intoxicated on November 24th, 2021, false at the time it was made as it related to Casey Hayden? Now, this is a preponderance of the evidence case. This is not a beyond a reasonable doubt case. You don't have to be sitting there in that jury box being 100% certain. I think at one point opposing counsel asked a question about, doctor, 100% certainty. I don't think we ever got that question answered, but I want to make it clear for you all, we're not here today on 100% certainty. Dr. Edwards told you that his opinion was to a reasonable degree of medical certainty. That it was plausible, most plausible, that Ms. Hayden was not intoxicated that day. You've heard evidence of vestibular migraines and the symptoms that being intoxicated and a vestibular migraine both share. That it might be difficult for the average person to tell the difference. The only two people that were there that observed her didn't have the training to know whether or not she was drunk or that she had a vestibular migraine. Now you might think, okay, well, what else were they supposed to think? Maybe in the moment, sure. Maybe that first November 26th email, hey, we're going to terminate you, you're publicly intoxicated. Maybe that's forgivable. Maybe they didn't have reason to believe otherwise. But then you heard testimony and you saw the letter from Dr. Edwards that was sent on December 8th. That was when AW Enterprises should have stopped. It was before anything was publicly put out, and they had concrete reason to believe that maybe they were wrong about their assumptions. Maybe someone with better training and better understanding of something had something else to say about the matter. But they just didn't believe Ms. Hayden. Ms. Bowman was the one who recommended her termination, and you know, Ms. Bowman doesn't really like Ms. Hayden. She called her things like classless and disrespectful. That's the opinion that Ms. Bowman had of Ms. Hayden, not the opinion of her thousands of followers or the brands that wanted to work with her. But they just thought that she was a liar. And the truth of the matter is, AW Enterprises could have stopped there and terminated her and moved on. But then they published an email about it. An email that could have said, Ms. Hayden's terminated, and again, stopped there. But instead, they gave a reason for termination and said it was public intoxication, despite concrete, credible evidence to the contrary. So for question number 3, the answer is yes. When you get to question number 4, we're going to be looking at whether or not defendant AW Enterprises knew or should have known in the exercise of ordinary care that the statement that was made was false and had potential to be defamatory. This is where the investigation comes in. This is where the evidence from the doctor comes in. Now, maybe AW Enterprises didn't know. Maybe they didn't have the BAC to determine it. But should they have done those things before they're going to publicly accuse someone of something? Shouldn't they ask the infirmary, hey, what kind of records do you have? Did you do an evaluation on her? Hey, maybe we should talk to her and get a statement. Maybe we should see if any of her friends saw anything. Maybe I should write a statement. Maybe this should be documented. But AW Enterprises didn't ask those questions. They jumped to conclusions when they wrote that email. So when you answer question number 4, the answer is again, yes. Opposing counsel got up here and ridiculed Ms. Hayden for her medical condition. She stood up here and she said, Ms. Monkey said, well, if you have such a debilitating medical condition, you certainly should stay home, shouldn't you? If it's so debilitating, you should just lock yourself in a room. That's how seriously AW Enterprises has taken my client's condition, not only when they were informed of it, but throughout this entire proceeding. Hasn't Ms. Hayden suffered enough?
You have about 4 minutes on your first 14.
To sit here and make fun of her for something she has no control over, something that's so embarrassing that she has no control. When she's in public, she might look like she's intoxicated to somebody else. But opposing counsel wanted to make a joke out of it today. And we're here today to talk about what they did and to talk about the damages that Ms. Hayden suffered, because she did suffer damages. I told you that we're going to ask you for some money. I told you about in the range of where we're at, and you agreed that if the evidence supported it, you could award it. So to take these things, we have injury to reputation in the past, injury to reputation in the future, mental anguish in the past, and mental anguish in the future. These are all things that may seem a little intangible. So I want to try to ground some of them in the testimony and the evidence that we've heard today. Starting with injury to reputation sustained in the past. Today is October 6th of 2024. The email was first sent out December 20th of 2021. So it's been about 1,021 days since this incident. Almost 3 years, not quite. Now, if you take the figure that Ms. Hayden provided, $100,000 a year, that she was making before this email went out, and then the figure that she gave today, what she's making now, $35,000, there's a $65,000 difference there. But since the year 2024 is not quite complete, we can round that down to 60,000 to be conservative. And if you multiply that by 3 for the 3 years, you land with $180,000. That's what we're going to be asking you to put for injury to reputation sustained in the past. For injury to reputation sustained that will reasonably be sustained in the future, we're going to look at the same numbers, but for 5 years. Here's why. If we were in a personal injury case and Ms. Hayden could no longer walk, we'd be talking about foreseeably the rest of her life. But Ms. Hayden is a young woman, and I've had the pleasure of getting to know her, and I've come to know her as someone who's resilient. I think that she's going to recover from something like this. So if we take the $65,000 that she lost annually and multiply it by 5 years, we land with $325,000. Mental anguish. Mental anguish is something that is hard for people to talk about. It's hard for people to explain, but you've heard from multiple witnesses how objectively embarrassing something like this is. To help ground this figure, it's $15,000 initially up front to join AW27, and then it's $5,000 a year after the fact. So if we're looking at the 3-year period of the past, $15,000 up front and $5,000 per year after the fact, for mental anguish, we're going to ask you for $30,000. I know we're asking you for a lot of money. I understand that we are. But you've heard how debilitating this has been, not only to her emotionally, but also to her career, her connections in the industry, her followers. Astroworld was her entire brand. Think about how emotionally draining and frustrating, upsetting that is. You heard it from her herself. Now for the future, I'm going to ask you to consider the same 5-year period and the same figure, but we're just going to do $5,000 a year for the price of the membership. And I know you might be sitting there thinking, why? It's because it's hard to quantify these things. And I just want to ground it in the testimony that you've heard and the money that has been expended and lost throughout this. So for D, we're going to be asking you for $25,000. AW Enterprises is the heart of Texas theme parks. It is one of the biggest companies in the state of Texas. With all the power and resources that they have to put out statements about club members, to conduct investigations, they made choices. And those choices affected my client's reputation. Actions have consequences. Hold AW Enterprises accountable and find them liable for defamation. Thank you.
All right, you only have you got about a minute left.
Thank you, Your Honor.
Let's have a public hearing.
permission to rearrange the well.
Yes. It's 4:35.
It's true. Actions have consequences. And I'm glad that plaintiff's counsel agrees with us. Every action, every choice we make has a consequence. Ms. Casey Hayden chose to be intoxicated on November 24th, 2021. And the consequence, the result, was that her membership was terminated. And the statement concerning the reason why was published. Our actions and choices have consequences. The evidence has shown that Ms. Casey Hayden was indeed intoxicated on November 24th, 2021. The two witnesses who were physically present at the scene have testified that they personally perceived, they saw, they smelled, they physically dealt with an intoxicated Casey Hayden. You heard the testimony of Ms. Spaulding and Officer Rubenstein, who testified that based on their knowledge, on their training, on their experience, Ms. Casey Hayden was indeed intoxicated on November 24th, 2020. You heard the record of Ms. Casey Hayden's membership, where she bought 6 beers. Credible evidence to show to you and prove to you that Ms. Hayden was intoxicated on November 24th, 2021. Versus what plaintiff showed you and provided you. They tried to paint a picture that has holes. And you can see right through those holes. Starting with plaintiff's expert witness, Dr. Spencer Edwards, who testified that he made his medical determination that Ms. Casey was allegedly suffering a medical condition known as a vestibular migraine. But you heard from Dr. Edwards himself that this is the first time he has testified that he did a physical examination on Ms. Hayden. But you heard from him, there's no record. There's no record of that physical examination he did on Ms. Hayden. He testified that he reviewed several documents except for that medical patient's record, which any doctor would rely on to make a medical determination on one of his patients. And apparently that medical record has been destroyed. Talk about missing evidence. Then you also heard from Ms. Hayden herself that she lost this big business deal. And she gave you big numbers, 15,000, 5,000. But you only saw a text thread, a thread that does not prove any amount testified by Ms. Hayden. Where is the 15,000? Where's the 5,000? Where's the 10,000 that she testified? There's no proof, no credible evidence. She also testified that she suffered mental anguish. And it's true, it's difficult to prove mental anguish, but it's not, to be honest. Where's the proof that she went to a physician, a doctor? Where's proof that she bought medication? Where's proof of going into therapy? There was no proof at all. To ask for $30,000 for mental anguish? You deserve the truth supported with evidence. And Ms. Hayden did not provide you a single evidence, single piece of credible evidence to back up the $30,000 request. No credible evidence at all. Whereas AW Enterprises, we provided you with credible evidence. The two witnesses who were physically present at the scene, you heard them testify that based on their perception, their personal perception, they saw, they smelled, they physically dealt with an intoxicated Casey Hayden. Ms. Baum and Ms. Rubenstein testified that they based their determination on their knowledge, their training, and their experience. And they determined that Ms. Hayden was indeed intoxicated. Credible evidence. There's no defamation when the statement at issue is true. There's no defamation when the statement at issue is true. And the evidence has shown to you that Ms. Casey Hayden was indeed intoxicated on November 24, 2020. Like counsel said, you're going to be asked 5 questions. And the first question that the judge is going to ask you to answer is the following. Did defendant AW Enterprises publish a statement regarding plaintiff Casey Hayden being publicly intoxicated on November 24, 2021? And the answer is absolutely yes. We did publish the statement. Question number 2. Was the statement in question one defamatory concerning Casey Hayden? The answer is no. No, because Ms. Hayden defamed herself on her own. You saw evidence of her Instagram post where she used profanity. Not only that, you also heard evidence of her use of profanity in a restaurant, in a family restaurant around children. It was her testimony. You heard it directly from Ms. Hayden. And not only that, prior instances of drinking. Ms. Hayden defamed herself on her own. So the answer to question 2 is no. But in the event that you have to answer question number 3, question number 3 states, was the statement that Casey Hayden was publicly intoxicated on November 24, 2021 false at the time it was made as it relates to Casey Hayden? And evidence has proven to you that that answer is no. Ms. Casey Hayden was indeed intoxicated on November 24, 2021. You don't have to go forward, but in the event that you have to answer question number 4, did defendant AW Enterprises knew or should have known in the exercise of ordinary care that the statement contained in question 1 was false and had the potential to be defamatory? No, because you heard from Ms. Baumann herself that they did their due diligence. They investigated 2 weeks. They had the documents that were provided by Ms. Casey, and they reviewed those documents. They reviewed Ms. Casey's response. They also reviewed Dr. Spencer's report. And based on that information provided by Ms. Hayden and what Ms. Baumann and Ms. Rubenstein perceived, they determined that Ms. Hayden was intoxicated on November 24th. You don't have to move forward on question number 5, but it's my job to talk to you about question number 5. And like I stated, the evidence has shown that Ms. Hayden was indeed intoxicated on November 24, 2021. There's no defamation when the statement at issue is true. So all the answers to question number 5 are 0. Again, there's no defamation when the statement at issue is true. And the evidence has proven to you that Ms. Casey Hayden was indeed intoxicated on November 24, 2020. On behalf of our client, AW Enterprises, my co-counsel and I want to thank you for your time and your attention. But most importantly, we want to thank you for your valuable decision. And we trust that you will return a verdict in favor of our client, AW Enterprises. Thank you.
All right, you got about a minute?
Yes, Your Honor. I want to remind you, members of the jury, that testimony is evidence. And listen, we talked about painting pictures. I'm no Picasso, but the picture of what kind of company AW Enterprises is quite clear. AW Enterprises is the kind of company that lies about their customers. It is the kind of company that fails to conduct investigations. It's the kind of company that points their finger across the table at other people. It's the kind of company that fails to take accountability for its own actions. You 12 have the power today to hold AW Enterprises accountable for what they've done. You have the power to tell them that they can't do this to anyone else ever again. Find them liable. Thank you.
All right, ladies and gentlemen, the evidence, the court's charge, and the arguments of counsel are now before you. In a moment, I'm excused to the jury room to begin your deliberations. The first thing you'll do is select the presiding juror, and then the presiding juror will direct the instruction, direct your deliberations. And there's a buzzer in the jury room. If you have a question or a verdict, our panel will instruct you as to how to use that. All right, we'll be in recess until the jury has a question or a verdict. The end.
Would you like us to step out?
I've already filled out my ballot. I don't know if you all have the verdict.
Yes, I guess they're adding them up.
I don't think you need to step out if you want to. I don't, did you all want to deliberate together?
Great job.
Great
job.
I'm not here.
Yeah, and of course, I will always learn. I'm glad to do it.
Christine, you need anything else? Yeah, I gotta run down to my office. Are you doing that right away? Or?
Yeah, like right now?
No, it was great.
Do what? Like very, very general, something that they use later. Yeah, I agree. It was good. Yes.
Yeah.
It looks at me on those sorts of things.
Alright. Alright, award things. It was like killed the live stream. you wanna give any real quick feedback to them, generally bless them, they can learn, they don't like.
I thought y'all were great. I think the openings were a little formalistic. I would like to see more, a little bit more storytelling. So you have a bit of a plot. So the jury's actually kind of gets hooked and wants to know more. And